Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers, with your hosts, Ben Siders and Kirk Damman.
Today's episode is brought to you by Simulation One software. It helps everyone's favorite actress, Simone, to be herself every day.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions and speculates wildly about the answers without ever figuring out what the answers might actually be. With your host, Ben Siders, that's me, and the other guy is Kirk Damman.
That's Kirk, as in the captain of the Enterprise.
We are IP lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders. You can find Kirk at KirkDMN, and you can follow this podcast on Twitter at LGGPod. What are we, Season 2, Episode 3?
Season 2, Episode 3. Yeah, we can't quite do episode numbers anymore. I think they're getting a little too big.
Yeah, we just asked our sound engineer what episode we're on, and he knows, but we don't. So anyway, we are joined today by special returning guest, Charla Claypool, who is here to tell us about rights of publicity and some interesting cases, kind of following on our last episode.
Hi guys, thanks for having me on again.
Glad to have you on again. I mean, I think everybody loved your last episode. We wanted to even sort of die in to get you back on the show here.
Yeah, so if you guys haven't listened to it, Charla joined us last season to talk about gaming law, gambling law, and that was Season 1, Episode 18, which is also just Episode 18. So go check that out if you haven't listened to it yet. And Charla, we have, I think, we're going to get into this in a little bit, I think we have a lot of new listeners now.
It seems
somehow.
that way.
So for all the new people who maybe haven't caught the prior episode, why don't you tell us a little bit about yourself and your practice?
Sure. I am a member in the IP litigation group at Lewis Rice. I've been with the firm for a total of 5 years. I took a little break for a couple years and worked in-house for Whirlpool Corporation in their advertising law practice group. In my free time, I enjoy cooking and horseback riding and cosplay.
Yeah, but were you talking about the fact that you were a cosplayer on this? Was it Elektra? Is that right?
Yes.
Okay.
And weren't you working on a Black Panther?
I was. During our last podcast, I was working on a Black Panther costume for the premiere.
Did you ever finish it?
Yes, and it went over quite well.
Awesome.
I was a proud Wakandan.
Very cool.
We are jealous.
Hopefully not one of the various ones that dies in Infinity War, but
Shh, I haven't seen it yet. Have you seen it now?
people die in Infinity War. Wait, I don't think I gave away any spoilers.
Spoiler alert. Have you seen it yet, Kirk?
I still haven't seen it either.
Charlotte, did you see Infinity
No,
War?
I have not seen it yet.
No, me either. Well, how about, so it's the week after Thanksgiving. How was everybody's Turkey Day? No takers?
I'll start off just what it was. I mean, we had sort of the classic, like family Thanksgiving. It was fun, sitting around, ate too much, watch too much TV. I think it's what you do on Thanksgiving.
Your family's mostly in town.
Yeah, our family's mostly in town, so we tend to have, especially Thanksgiving tends to be here. The out-of-town guests tend to come here just because I think that's more fun.
Easier.
The great thing about it, we have them too, is it's because there's just a bunch of small kids in the family now. They just disappear.
Isn't it great?
Yeah, and so all of a sudden, it's, where are the kids? They've been quiet for, 5 hours.
Who cares? They've been quiet for 5 hours.
So,
Charlotte, how about you?
We were here too. My family's mostly local, so it was my mother's year to host Thanksgiving. I hosted last year, so I got a break there. But then 2 days after Thanksgiving, I hosted Friendsgiving at my house. So I got to do all of the cooking again, but it was a lot more fun. A bunch of my friends and I do a Thanksgiving punch recipe contest.
Very
with
cool.
Okay,
blind
that sounds
taste
fun.
testing, which is a lot of fun and also not so much fun the day after. But a lot of fun that night.
I don't follow you, Charlotte. What are you talking about?
we had a friend who actually used to do an event called Beersgiving.
Oh, yeah.
And the requirement of Beersgiving is that it's essentially a potluck, except every dish must be cooked with beer, and you must bring the beer in bottles or however form in addition. So you can have sort of in conjunction with it, which gets really interesting because there's a lot of things that would make sense to have beer in, but the highlight is always, I know he would brine the turkey in Belgian Tripel, basically.
Really?
Which was incredibly good.
Really?
Wow.
Yeah.
That takes a lot of beer.
Yeah,
If you're
it takes
talking about a 20-pound bird.
Well,
I think he
Belgian
went through an
Tripel is not
entire
the
case.
cheapest of beers.
I was going to
either.
say, and not cheap beer at that.
Yeah, I think he went through an entire case of big bottles when he
Wow.
did it. But,
Along those lines, my wife this year, this was by far our most successful turkey. which I'm going to take 100% credit for without any justification because I did all the basting because she was gone that morning. But she took the gravy and added bourbon to it, which was very good. Ooh. So yeah. She didn't tell me she'd done that, so I tried it. I'm like, this is the most amazing gravy I've ever had. She's like, it should be. There's a bunch of High West in there. Yeah. We also saw Wreck-It Ralph 2 Thanksgiving weekend. I took the kids out to see that. You guys seen that one yet?
Nope. I kind of want to see it though.
It's pretty good. It's not as good as the first one. It's sort of. It is what it sounds like. They get out onto the internet, and there's a lot of internet jokes. I didn't feel like the script was quite as tight and sort of well crafted as the first one. There's a couple moments where like things happen and they happen according to the artificial rules of the Wreck-It Ralph universe. And if you saw the first one, you'd be thinking, I don't remember that being part of the rules of how this world works. Then they explain it. Oh, yeah, that's how that works. So, whereas in the first one, a lot more of that was sort of set up in advance. Like glitches can't leave their game. There's like things like that the plot sort of depends on, and they sort of lazily introduce it just when they need to. Okay. Sort of a Deus Ex Machina type thing. But it was still good, very enjoyable. The climax of the film is a little disconcerting.
Anticlimactic?
No, it's good, but like visually, it's kind of weird to watch. Like there's a giant Wreck-It Ralph monster made of little tiny Wreck-It Ralph monsters, and they're all sort of squiggling around. And if you look at the screen for too long, it's like looking at like a wriggling pile of worms. I don't know. I didn't like the visuals, but it was a good movie. It was funny.
I don't know, but my favorite with Wreck-It Ralph 1 still is Sugar Rush, and the fact that I was singing that like stupid theme song for like 3 hours afterwards.
Yeah, we were too. In fact, I think I actually downloaded it. I think I bought a copy off iTunes because my kids were really into the soundtrack for a while, and they like to dance to it. Anything else you guys have been watching lately?
So I actually, I don't know if we talked about it previously, so I've been catching up on movies and using that on my treadmill. I just finished Arrival. Which we were talking about. I loved Arrival, and the comment we made with it, to my mind, like Arrival's classic science fiction, as in it's science that just happens to be fictional.
Yeah.
And you know the concepts behind it. There's some really sort of great scenes. It's really a discussion of what is language, and how does language affect your perception of the world, and that's really what the thing's about. What I really liked about it is there's like scenes in it because they talk about like they eventually have to communicate using written communication because basically we can't make the correct sounds, and they're not sure the sounds connect to the writing.
Probably give a quick overview of the plot. For
so the basic thing is aliens arrive. They're trying to communicate with them. You have a linguist arrive there and try to figure out how to communicate with them.
They arrive and don't immediately set about destroying the planet or enslaving us all.
It's not Independence Day, yeah. but yeah, that kind of thing. And so it's trying to figure out anything we know. We obviously they can talk to them. They appear to be fairly friendly, but they're standoffish.
But there's no like verbal language, right?
They have a verbal language where they sort of click and buzz.
Yeah, but we can't really understand it.
Yeah, and they later determine they say at one point in time during it, once they figure out the written line that they get written language communication, which this linguist does. She makes the comment at one point in time during the movie that the sounds don't appear to have any connection to the written language, so she's not even sure whether or not the sounds are language. But the key is it's a lot of written language about it. But one of the key things is that it's a very hard language to write because they talk about the fact that it's the entire sentence is prepared at once. So they said it would be like writing from both ends of a sentence simultaneously and meeting in the middle. So you not only have to know what the sentence says, but exactly how long it's going to be before you start writing.
Yeah.
Wow.
And that's kind of a cool presentation. But one of the things is when they're trying to do the written language, the way they do it is she's like picking runes on her computer. And you see, every time she does it, you see her tablet, you see her touching the runes. And then it shows like behind her, you see a computer like put the thing together. And then you see it kind of adjust it into the right shape and then display it. Which is exactly what you'd expect. Like, basically, you're feeding this kind of thing into a computer, and then the computer's saying, okay, like, it's supposed to fit in this area. Let me adjust it, put it together, and make sense, which is something you, as a human, we just couldn't do.
Yeah, I thought Arrival, I've also seen it, probably one of the best science fiction movies I've seen in the last 5 or 10 years.
And again, it's hard science. I mean, that's the thing with it. I mean,
it's an unusual science. Like, it's really about linguistics and syntax and language structure. And you're right, the theme really is about how the way that we learn to communicate affects how we think about things. And the aliens in this movie, their language is all based on circular structures, which also influences how they think about the universe and conceive things. And that's a little bit of foreshadowing for things that happen in the movie. We won't get into spoilers.
Doesn't give it too much away. We won't get into spoilers.
No, they established that within the first 15 minutes of the movie. But,
so that was a pretty cool movie. And then the other one I just watched Plastic Galaxy, which was something I kind of found literally on Prime here, just looking through it, which is essentially a documentary on Star Wars toys. It's what my comment with it is I actually found it a very interesting movie, and just sort of seeing the background. They interview a bunch of Kenner execs, like major collectors. They talk about like weird, things in the history, like prototypes that never got made, like the Boba Fett whose jetpack actually launches missiles. That was what was advertised but never sold, stuff like that.
There are people who swear that they got one.
Yeah, and that's not true. I mean, I collected Transformers toys for a while, and there are people who swear that they got a blue streak as well in a box, and it never was there.
Like phenomenon of people having collective false memories.
Yeah.
Have you read any of the articles about that?
Oh yeah.
Like there's whole groups of people who
they're
thought
aware
they
of these
remembered
things,
Nelson Mandela dying years ago.
Yeah, it's wild stuff. It's that what I basically say about the movie is if you're kind of into toy collecting and stuff like that, it's a fun movie because it gives you a lot of like interesting documentary stuff. I wouldn't say it's great filmmaking. It's, to my mind, it's somebody who's probably just graduated from film school or about to graduate from film school, like a final project. It's got some campy special effects in it that it totally doesn't need, and like transitions it doesn't need.
It sounds like something where the subject matter is interesting enough that it's easy to write a documentary, but probably hard to pull it off and make it look super polished.
And that's the thing, is it really doesn't look very polished. I think that, like you read the reviews, and I think a lot of the comments were that, it doesn't look good. And it's like, well, it's not a polished movie, but it's a very interesting movie, and just sort of what it presents.
You can still make it
portrays.
Interesting for a documentary, especially.
Yeah. And recognizing that, and I think it's very true, the Star Wars toys completely changed both the toy world and the entertainment world in many respects. And they really talk about why and how and like what this did to Kenner and like stuff like that. And it's really interesting.
Charla, how about you? Anything interesting you've seen lately?
I actually recently bought a subscription to Curiosity.com, which is the all documentary version of Netflix. Yep. I'm a big documentary. So I've been checking out some things there. Most recently, I was watching things that I've seen 100 times before, because we have a tradition over the weekend after Thanksgiving. That's when we binge watch all the fantastic Christmas movies.
Yep.
So Christmas Vacation, and then continually drop quotes from it for the next 48 hours.
I was going to take the garbage out the other day when we got that big snowstorm, and I was running late because I could hear the truck coming, so I just got like my robe on. I threw my dress shoes on, and I'm running outside to take the trash out. And as I'm getting to the curb outside in the snow with my robe on, my neighbor comes by in his car, rolls down the window, and says, "Morning, Griswold." So, Jared, if you're listening, you are a legend. Other interesting things. So my 5-year-old currently is obsessed with a movie on Netflix called Next Gen. Did you guys hear of this one?
No. Next Gen, I think Next Generation Star Trek.
Yeah, that's what I think. No, it was made, I don't know who made it. It's on Netflix only, but the cast has John Krasinski from The Office, Michael Pena, David Cross is in it, Jason Sudeikis, is that how you pronounce his name?
Sudeikis.
Is in it?
I don't know.
Constance Wu, who was recently made very famous from Crazy Rich Asians, if you've seen that. Okay. I haven't yet. And then the main character is voiced by Charlene Yee, who, if you don't know who that is, she played the frequently enlightened girlfriend in Knocked Up, who was... she was high all the time in the show. Jodie was her character. So a great cast, but this movie flew completely under the radar. At least to me it did. I'd never heard of it. Charlie found it, my son. John Krasinski voices a robot, and the plot is basically a story about dealing with loss and abandonment and things like that. It's okay. But it's weird because the visuals are very like kid movie-ish. The robot is very shiny and has a happy faces and it's very expressive. And it's John Krasinski, who's like the nicest guy. But then like the themes are a little on the PG-13 side. There's a lot of sort of comic book type action. I guess Charlie likes it and he's 5, so it works. But it's a little. The themes are a little misaligned with what it looks like. So you're watching it and thinking it's going to be like a little kid movie, but then it's kind of not. So anyway, it's an interesting one. It's worth seeing if you're into just animated sci-fi. But other news, podcast stuff. Kirk,
yes.
November. Yep. November's been ridiculous so far.
Yeah. Apparently, what we did the last episode, everybody liked.
I guess. I haven't figured this out yet. So for context, the best month of this podcast for a while was our first month. We launched in August of last year with 6 episodes in the can, and it took until this last May before we had more listeners than we had that first month. And then May, June, July each set new records, and then in August we went on sabbatical and didn't have a whole lot of listeners because there was no new content. And then we came back this fall and set a new record for us, at least, for listeners. November blew that away. We exceeded our prior record by 20%, and it had been creeping up about 5% at a time. And for whatever reason, y'all must have really loved the NCAA football game because
and 20% wasn't that we added one new listener for the
right.
5 we already had. No, it was actually a large number.
Yeah, November absolutely crushed it. So y'all love that episode. Apparently, it is in our top 5 most listened to episodes of all time, and that's saying something because that one's only been out for a couple weeks.
Yeah, and we've had other episodes that have been
out for over a year. So those of you who are joining in, who are new, who like that episode, let us know why. First of all, we'd love to hear from you. But thank you for coming back and listening to more episodes.
And we think you're going to like this episode even more.
Yes, indeed. One more thing before we get to the sort of the meat and potatoes of this episode, we have a Sabacc lawsuit update, Kirk.
Yep. For those of you who don't remember, we talked about the Sabacc lawsuit previously. I mean, Ben raised it. Company trying to essentially make the Sabacc game.
They actually got a registered trademark on it too.
And then went and got a registered trademark. And this was they got the registered trademark around when Solo came out.
Yeah, they got it I think 6 months in advance.
Okay.
And then and then Lucas filed an action to have the trademark canceled.
Yep.
And then filed a lawsuit against the company for infringement of Lucas's copyrights and trademarks, I think.
Lucasfilm, right?
Lucasfilm, yeah. And then the trademark cancellation proceeding was suspended, and then the company filed a counterclaim against Lucasfilm for their Han Solo movie infringing this other company. The company's called Ren Ventures, for infringing their Sabacc trademark. And then they filed a different lawsuit against Lucasfilm on top of that. So a real mess. Charlotte's looking at me very quizzically.
That's a lot of lawyers.
That is a lot of lawyers. A pretty gutsy move for a company that's, I think, Kirk, we would agree, was flagrantly taking somebody else's concepts.
At least, yeah. I mean, they were definitely using something which, came from somewhere else. I think as we discussed in conjunction with this, whether or not it rose to the level of trademark infringement was an interesting legal question.
They were
because
trying
there was
to squeeze,
no necessary good that had been sold under the name Sabacc prior to that.
They were definitely trying to squeeze between the cracks of copyright and trademark.
Yeah, there's no question about it. This was walking the line.
Yeah, they did not walk the line. They fell right off.
As now has come down, I think that's the thing we got from the update is, this was not walking the line.
Yeah, so the case is over. Lucasfilm won, not because the lawsuit went forward. It settled, but I'm going to put settled in air quotes here. Normally when a case settles, and Charlotte, you know this from doing IP litigation, you write a settlement agreement. It's usually confidential. It never sees the light of day.
Yep.
And the only thing you tell the court is, we settled. We're done.
Mm-hmm. And occasionally there's some statement that the parties don't agree.
Yeah.
There's
almost always no admission of
responsibility, anything along those lines. It's sort of made specific.
That's not what happened here.
Not at all.
This was a stipulated consent judgment and permanent injunction. Charles looking at me like, oh my. Yeah. So Ren Ventures had to dismiss its counterclaim with prejudice. It had to dismiss its other lawsuit with prejudice.
Just so we know, people who aren't involved in legal sort of worlds here, with prejudice means they can never raise it again.
We dismissed it and we will never raise it again. They had to voluntarily surrender their trademark registration. The stipulated injunctions, or permanent injunction, means that you can never do whatever the injunction says you cannot do. The injunction prohibits them from using Sabacc at all in any way. But it also includes more. So here's a quote from the order. Ren Ventures is prohibited from, quote, using any element of plaintiff's Star Wars franchise, that's plaintiff's is Lucasfilm, in connection with the sale, offering, distribution, marketing, or other exploitation of any services and products of any defendant, or otherwise engaging in any other activity that infringes, whether directly or indirectly, any Lucasfilm copyright. So that's any element of Star Wars.
Yeah.
Not only can they not use Sabacc, they can't can't even whisper the word X-Wing in a dark alley.
Yeah, and that's the key about this is this is not just saying they can't use Star Wars trademarks or anything like that. They can't use anything associated with the franchise.
Element. I mean, that is broad.
That is broad.
That is everything. Like, have you seen those Adat Walker Christmas sweaters?
Yeah.
Like, can't even make one of those.
No, I think Lucasfilm licenses those.
I'm sure
though.
they do. Yeah. If not, there's another lawsuit coming. And the cherry on top is they had to pay Lucasfilm $470,000 in damages.
Wow.
Yeah.
So
That sounds like a loss to me. Not
I think that's what we say. It's a settlement, but I think we say that Lucasfilm won this. My take of this is, and I remember we always used to refer to this in law school. You guys probably did the same thing. This is the result, which is the thou shalt not.
yes. And we talked in the last episode about how the character for hire companies, that Disney's lawsuit against them is going forward. They're also, I think, trying to skirt that line between copyright and trademark and get away with something. And this kind of looked to me like Disney really flexing a little bit and saying, you're next.
I've also got to wonder if it involves like the lightsaber training, guys doing that kind of stuff in conjunction with exercise and sword fighting training and stuff like that. I wonder
What's
if that's
interesting
also
is,
associated.
Lucasfilm, and I think even now Disney, Disney's historically been more aggressive in enforcement than I think Lucasfilm was.
But Lucasfilm was very specifically not aggressive.
Yeah, even now, like there's all kinds of Star Wars fan stuff out there that I think is mostly let go. I don't see a lot of it that's truly just Star Wars fan content being taken offline. But this was different. This was a company that was...
Oh, this is clearly a very commercial venture. And then you also got to remember, they turtled up and struck back. This was not something where they basically said, okay, we'll agree.
In a pretty audacious manner.
Yes.
They accused Lucasfilm, that'd be like me making a Windows program and then suing Microsoft, for infringing my Windows when I got the idea. It was just strange. And I don't know if there's more to it than what it looks like. Just on the surface, I did not understand the strategy, and I think the brazenness of the of Ren Ventures' approach to this may have motivated the severity.
The severity of this settlement. Yeah,
the settlement is in quotes. This is your company is now over. Thank you for trying.
And I think it's worth. And I think it's a good sort of thing to point out with this. We talk about in this show a lot of the idea that we don't know what the outcome of cases is going to be.
This is a rare one where we do.
Yeah, this one we really clearly do know what the outcome of this is, and it also sets. This one sets a very clear ground of what you can't do. It's.
Oh yeah. We have a judgment now. So now we have res judicata. We have claim issue preclusion. I guess.
Preclusion,
yeah. There's other.
And I think it's a very important thing. I think it's a very valuable thing to sort of note that hey, we have this decision on this, and it's also one that for those who have been longtime listeners of the show, or for those who go through the back catalog, you'll hear we were talking about this when it first came down. We didn't know how this case was going to come down. There were some interesting legal questions here. We now have a very definitive answer. Now again, it is still a settlement, so it's
a stipulated. It's not a finder of fact looking at it and saying Lucasfilm, you're right, and Ren, you're wrong.
Yeah.
It's Ren saying, I can't out-lawyer Disney, so we're done.
A court could technically still overrule this as the law. You can't necessarily say this is the law.
Yeah, it's a judgment that's going to be effective and enforceable between these two parties.
Yes.
So there is that, and there's some other language in there about this company can't also go make a new company and do something similar. They third-partied into the judgment an individual that was involved in this. This seemed to have really rankled the ire of Disney. So, but like I said, it kind of felt like a shot across the bow to me. Like this is going to be the new normal. So tread carefully. Speaking of the new normal, Charla, this is going to speak to your last episode. Just last night,
and this is last night as we're recording this.
Yeah, we're recording this on the Thursday before it launches. So what is it,
next week?
27th? Would have been last night?
Yeah, 27th.
I can't keep track of dates. Late last night, the FTC affirmed a pledge to investigate loot boxes, following up on a request by New Hampshire Senator Maggie Hassan, or Hassan, I don't know how to pronounce her name. There's some articles out there on this on IGN, and I found one on Polygon. The issue, apparently, this is a quote from Senator Hassan. Loot boxes are now endemic in the video game industry and are present in everything from casual smartphone games to the newest high-budget releases, end quote. The senator added that loot boxes will represent a $50 billion industry by the year 2022.
That's really kind of amazing, actually.
That is pretty amazing. The concern is that it is a close link to gambling, and won't somebody please protect the children? So, Charla, what does it mean to say that the FTC is going to investigate?
So, in my experience, this is the start of a long course that I would say 50 to 70% of the time ends in the FTC giving some sort of formal guidance document that's going to be codified in the CFR telling us what the rules are. This is one of those areas, as you'll remember from our last podcast, that we talked about, when do you cross the line in gaming from recreational gaming activity to being an illegal lottery? And it's something we've all kind of speculated about. Well, here's where we think the line is. Here's where some of the court cases are taking us. But I think this is probably the first step in the FTC saying, well, it's time to define where the line is. They followed a very similar process a few years ago before they released the now very famous endorsement and testimonial guides for blogger engagements. For the listeners who aren't familiar, these are guides that talk about what you can and cannot do when you are hiring social media influencers, celebrity bloggers, in order to do reviews of your product. The FTC has for decades had a rule that if you are hiring a celebrity or an expert to give a testimonial about your product, you have to disclose the fact that you've paid them to do it. Now, up until the rise of Facebook, Twitter, etc., that was a pretty clear standard to follow, because if you pay Michael Jordan to go on TV wearing Nike, it's pretty clear.
You paid Michael Jordan to go on TV wearing Nike.
You paid Michael Jordan to go on TV wearing Nike. Where this gray area came in was, let's put it in the gaming context, some of these YouTube gamers who have millions of followers all of a sudden start getting games in the mail from Microsoft and from Nintendo and saying, hey, we love your stuff. We want to send you a free game. I hope you and your viewers enjoy it. And then the question becomes, well, does that influencer have to disclose when they're playing that game in their videos that they got it for free? Would that influence a viewer's perception of the feedback that influencer is giving on the game? Think about it. If you know the guy got it for free, in the hotel industry, they're dealing with it a lot now. A lot of these travel blogger influencers, that do these stunning reviews of hotels around the world. Well, I'm going to look at your review a lot differently if I know that you got a week at the Four Seasons Maui for free in exchange for reviewing it.
And not in the cheapest room either.
No. I'll say nice things about any hotel that gives me a week someplace warm for free.
Hint, hint.
Hint, hint.
We're not officially looking for sponsors, but it sounds like maybe Charla is.
Well, I mean, I believe, talking about bloggers, I believe a podcast would qualify as that as well. So if we have any paid sponsors that would like to send us to Maui for a week, we will gladly admit you're a paid sponsor.
Yeah, so when all that was going on, the FTC followed a very similar course. They started with an investigation into blogger and influencer practices. And then there were a series of public hearings. And, there was comment back and forth. And after about 2 years, we got the updated endorsement and testimonial guides that gave specific examples of different online blogging influencer activities and examples of, do you need to disclose in this context or not? So that, and now we have seen from the enforcement side, their first step was they sent a group of nasty grams to an undisclosed list of advertisers, saying, hey, as you know, we've released these guides, and as you know, they say that this is what you should be doing. We've seen activity from your company that does not appear to comply. Start complying, or you'll be hearing from us again, and not in just a nice letter.
So basically, we can expect them to examine this. If there's a need for rules, put the rules out there, and then give these gaming companies some time to voluntarily comply with them before they start showing up with a sock full of quarters. And say.
Typically, yes. They do also sometimes, pick a company to make an example and make a statement right out of the gate. And with the endorsement and testimonials, it was Lord & Taylor who got the business end of that and ended up in a consent decree with the FTC.
Who would that be for gaming? Like, what's a game that everybody loves, that plays it, but everybody who doesn't play it hates it? The only one I can think of is Fortnite.
Fortnite is the one
Everybody over the age of 30 hates Fortnite.
The thing I think is interesting about this, and I think, we talked about earlier when sort of last time we were on the show, sort of what is it, what is the difference between gambling and sort of things like that. It does seem like, and I just know this from some of the games I play, the nature of loot boxes has changed in probably the last 6 months. It used to be, yes, it's a loot box and it includes one of these 5 things that are all sort of roughly equal value. Now it seems like a lot of times what it is it may include one of these 5 things that's of roughly equal value, but there's a 5% chance it includes this one thing of much greater value. And again, I'm saying value in the idea of like how much it would cost directly in the game or how much people would want it, stuff like that. I have to wonder if maybe this is a little bit in response to that sort of these loot boxes are changing a bit to the idea that there is a little more of a gambling aspect. Like games I play, people have commented about not wanting to put money into the game because they're like, I don't want to spend $100 for a 20% chance. I'll gladly spend $200 for a certainty, but I won't spend $100 for a 20% chance or a 50% chance.
We should probably talk about, just really quickly, Charla, what are the elements, traditionally the elements of gambling? What makes something gambling versus not?
Sure. So we talked about this a little on our last podcast, but there are 3 elements in pretty much every state of what constitutes illegal gambling. The statutes word it a little differently, but the 3 elements are there has to be a prize, so you have to be giving away something of value. You have to be giving it away by chance, so random numbers, some element of chance, and then the entrant has to give some sort of what we call consideration in order to have a chance to win the prize. Now, the most traditional element, the most traditional way you see that is think of your lottery ticket. You spend money on a ticket with numbers, and then there's a draw of randomly pulled numbers, and if you match, you win a prize.
So you can only do that if you comply with state regulations that govern the gaming industry.
Yes.
Correct. Unless you are a licensed casino or a state lottery, you are most likely breaking the law if you are conducting any enterprise that involves those 3 elements.
Or in St. Louis, bingo.
Yeah. Or you are a 501c3 charity doing it for charitable purposes, and even then you need to talk to your lawyer because some states have rules about what you can and can't do even as a charity.
Yeah, there's certain things you can't. There's also always certain things you can do, limitations on what you can give away, stuff like that. Yeah, I was when I was in band in high school. We ran bingo in Colorado, and that's what you can do in bingo when you're a 501c3 charity, and what you could do when you were a licensed casino because we had reservation casinos. Out there are 2 entirely different things.
Wasn't there a high school that got in trouble for this? Like some high school, this is a long time ago, did like a casino night for the post-prom. And anybody could, all you had to do was go to post-prom, and you got to have your chips and participate, and they thought, well, we got around it. But you had to pay to get into post-prom.
Yep.
Whoops.
And, in the gaming context, it's been a big question for the folks like me who are both gaming nerds and sweepstakes lawyers of, where do these things like loot boxes stand and in-game purchasing? How does that work? Because if you think about it, you're going to pay for a loot box. What you get and where something drops in a game is by chance. And the critical element has been, what is a prize? If it's, hey, you're paying money in game and you're going to win an Xbox 360 that gets mailed to your house.
That's a pretty concrete prize.
That's a pretty concrete prize. But where do things stand? Like, military packs or extra health, extra XP.
Like things that just exist in the game.
And only have value in the game universe. And what we've seen, again, we didn't have a lot of real definitive court ruling, but it seemed that the way regulators were deciding who to go after and who to leave alone was that as long as what was being won did not have any value outside of the gaming universe, That was something they left alone. Now, there was always this interesting side question that the legal nerds debated in bars of, well, we all know that there are these secret secondary markets out there where people buy and sell things
which are almost
with
always
real money.
But those things are also almost always violations of the license agreement of the game.
Correct.
So let's put that out that they are violating the
I
license
may or may
agreement
not have
of the
sold an
game.
EverQuest character back in the day. Well, the Entertainment Software Association was asked to comment on this, and this was their quote. Loot boxes are one way that players can enhance the experience that video games offer. I think we'd all agree.
Yeah.
Contrary to assertions, loot boxes are not gambling, remains to be seen. They have no real-world value. Players always receive something that enhances their experience, and they are entirely optional to purchase. They can enhance the experience for those who choose to use them, but have no impact on those who do not. I'm not sure I buy that last part.
Nope. I'm not sure that I do either, and particularly in light of a Ninth Circuit case that came down just a few months ago at the end of March. It's the Big Fish Casino case, if folks want to pull it up. Big Fish Casino was an online casino game where you got free chips, and over the course of the game, when you played, more free chips would drop or be awarded. You know, there were free chip Tuesdays if you logged in and you got them. There were non-purchase ways to get chips to play with in the casino. You could also, of course, purchase chips to play with in the casino, which one lovely lady did to the tune of spending thousands of dollars on chips to play in this casino. The prizes that you won were more chips to be used in the game. And she ended up filing a lawsuit, I assume, after going to Gamblers Anonymous and getting cleaned up and deciding how she'd been wronged of all the money she lost. And the case was in Washington court to begin with. And I assume Big Fish Casino made just that argument that, hey, first of all, she didn't have to buy chips. You could get chips plenty of other ways other than buying them. So, you know, no consideration. And also no prize, because these are coins that only have value within our little casino universe. And when it went up to the Ninth Circuit, the prosecutor made the argument that, one, while yes, there are ways to get them by hanging around, it's pretty clear that there is a huge advantage if you're out there spending money to get these chips.
Especially if you're playing like poker or something, where like if you get the fat stack at the table, you can bully everybody else out of the game.
And they also said that once you win more chips, that allows you to play in the casino longer. And what the Ninth Circuit said was, hey, there is a value in being able to continue to play for 5 or 10 or 15 hours longer than you otherwise would have. So yes, there is a prize element here. So you've got your 3 elements. Interestingly, they did not address the issue of the secondary market, because they said in this particular instance, the terms of service for the game clearly said that you were not supposed to make little side pack deals, so it was irrelevant. So we didn't really get a good court opinion on where a court's going to stand on evidence of there being a secondary market. And to your point, Kirk, almost all of the terms of service prohibit it.
Yeah.
So if there are any game manufacturers out there listening who are concerned about how to address that argument, this court case, I think, is just giving you a good out. Make sure that your terms of service for the game clearly prohibit any secondary marketing of in-game features.
One of the things I think is interesting, and I got to wonder about sort of the things with the loot boxes, I have to wonder if also part of the reason we've seen more loot boxes coming up with games is because of, I think, a lot of gamer general outrage of the pay-to-win arguments. And so it's the kind of thing where they look at it and say, you know, yes, you can pay and you can just get more chips, which does make it easier to win. You can be the bully at the table, whatever it is. The way to get around that is to say, well, there's now there's this secondary thing which you don't have to pay for or which you pay less for, which could give you that same advantage. So that way when you play against somebody who has, this spiffy, unique hat you have to buy, they could have won it. So therefore, you can't necessarily say it's a pure pay-to-win type of scenario. If that may have led to some of the rise of the loot boxes, but in the course of doing that, they're actually now opening themselves up to a second problem, which is this is it gambling question.
Yeah, it's also interesting, this particular, we should say what the FTC does. It's the Federal Trade Commission, right? It's supposed to be a consumer watchdog organization at the federal level.
They are the Federal Consumer Protection arm of the government.
And this is the group that's presently in charge of enforcing like the net neutrality rules and stuff like that.
Yes.
They weren't, then they were, then they weren't. Yeah. So that's what they do.
The FTC and the FCC often have jurisdictional battles.
Yeah.
And I think net neutrality was the latest one of those.
I don't think it's over. It's a whole separate episode we're going to do at some point.
We've talked about doing that as an episode at some point in time. Yep.
Well, so the Senator Hassan, who brought this up, her concern is that children are being, psychologically conditioned for gambling and stuff like that, and that other countries regulate these things. My first thought in response to that was we already have COPPA. We already have a Children Online Protection and Privacy Act. So, in theory, kids shouldn't be able to put money into buying loot boxes without at least some level of minimal parent knowledge or opportunity for knowledge.
I know some of the games like my kids play, when they play the online games, there is one way to put money into the account, and that's, it takes my fingerprint, stuff like that to access the pay thing for it. And it's not something where like you can buy loot boxes or anything along those lines. Yes, there's random events, there's things you can get, but if you subscribe to the game, you just get, here's X number of gold coins, and you can spend them on, there's things you can spend them on that are anything. And even if you never put 1 cent into the game, you're going to get a bunch of this stuff anyway. It just allows you to get it faster, basically.
And then the FTC, this is a federal investigation, but these anti-gambling laws mostly exist at the state level. So we may see the feds come in and set some rules down. And then, Charla, how does that relate to the states? Like, once people violate, assuming they do, violate these future federal regulations, does that give the states more arguments to come in and say, well, look, the feds say you're done something wrong, so...
Yes, I think it does. Now, it's not a direct, because you violated a federal law, you have therefore automatically violated a state gambling law. But if I'm a state attorney general and I see that the FTC has already come down on you for something, that's going to make my job a whole lot easier in bringing charges against you.
It sounds like the feds are going to look into this primarily from the kid perspective, which, that's one issue. But, gambling is illegal in most states, regardless of your age.
I believe there's pretty much one state it's legal in, and then a few smaller areas.
Yeah. All right. Well, that's an interesting topic. We could talk about that forever. But we're going to move on and talk about rights of publicity. That's one of the things we talked about in our last episode involving the NCAA football game, a video game, which was canceled because if you haven't listened to the episode, go check it out. But basically, the court said you have to get license likeness rights from the players. EA said we'd be happy to. The NCAA said you can't. The players said that's an antitrust. The court said yes, it is, and then everybody lost.
Yes, pretty much everybody lost. And again, if you haven't listened to that episode, that is our immediately prior episode that we talked about. We touched about it earlier on. It was a very popular episode, apparently. It's probably not a bad idea if you haven't listened to it to go back and listen to it, because obviously we're going to be talking a lot about the same kind of legal things here.
Yeah.
And I think Char's going to put some interesting spins on this and go into some of the places that I'm not sure right publicity we necessarily thought was originally going to go.
No, we talked before about the Baby Murloc case where a Blizzard employee was asked, like a casting call went out. Charlie, have you heard of this one? Casting call? Not. Went out in Blizzard saying we need people to come in and do some voice acting for some sound effects. And an employee said, that sounds fun, and went and did it. At some point, much later on, was no longer employed by Blizzard, I think, and then filed a lawsuit against Blizzard, violating her right of publicity in the sound effect that she made, which was a Baby Murloc. And if you know what a Baby Murloc sounds like, it sounds like...
It's a fish man.
Yeah, it's a fish sound. So she lost because Blizzard owns the copyright, and the Ninth Circuit said that any right of publicity claims are preempted by the Copyright Act in the sound recording, and that was that. And that's a long line of cases that goes back to Nancy Sinatra and other people. But Charla, why don't you talk to us a little bit about what rights of publicity are, why we have them, and some fun cases.
Sure. So the basic of the right of publicity is, and again, this is something that's recognized in most states either by a statute that specifically sets it down or by case law, is that every person, not just celebrities, owns the rights in their name, voice, likeness, persona, anything that could be considered to identify them. So that persona one, people always ask me about, well, what's a persona? And there's actually an interesting case that I like to use to describe it. So some of our listeners might remember this car commercial. It was in the early 90s. There was a car commercial. I can't remember the make of the car. I want to say maybe it was a Honda, but the whole thing was about the reliability of the car and how long it was going to run. You know, this car is going to last forever. And the last scene of the commercial was this car on a stage of a Wheel of Fortune set being offered as a prize. And right next to the board with all the letters was an android C-3PO looking figure with a blonde wig and an evening gown on. And Vanna White promptly sued.
And we've talked about this before. This is Vanna White.
Yeah.
Yep.
So this is Vanna White. She promptly sued and said, hey, you have appropriated my persona. And of course, the car company said, no, we didn't. There's not a single picture of you. Nobody said Vanna White. Nobody used your voice. Go away. And the court said, come on. Who else wears evening gowns and has long blonde hair and flips letters on a game show?
I think it's the flips letters is the key component of it. The evening gown and the long blonde hair is probably reasonably common.
Another more recent one was Michael Jordan's lawsuit. I don't know if you guys have talked about that. But Dominic's Grocery Stores, after Michael Jordan was inducted into the Basketball Hall of Fame, ran a full-page ad. And all it had was a picture of a basketball court and a pair of black and red Air Jordans with a number 23 on the side. And it said in very general terms, greatness is all these things. It's determination, it's commitment, it's blah, blah, blah. Congratulations from one committed Chicago native to another, or something along those lines. So never said Michael Jordan.
Clearly being very careful.
Had a picture. Yeah. They clearly were very careful not to mention Michael Jordan. And of course, Michael Jordan sued. And they said, well, hey, never mentioned your name. There's not even your likeness anywhere.
It's a pair of shoes, yeah.
It's
and the number 23,
with the number 23. And again, the court said, come on. Who else plays basketball when you see a basketball court and red and black shoes and the number 23?
In Chicago?
In Chicago. Who else would you think of? So I would be interested to see in that Blizzard case, you know, one of the arguments I would make if I'm Blizzard's lawyer is get 15 of this girl's friends into a room and have them listen to that sound. Can they really identify that, oh, yeah, that's my friend Megan's voice?
Yeah, obviously.
No,
that's exactly her trademark fish sound.
Yeah, exactly. Yeah, and I think that's part of the reason why you get into those kind of things. There's a lot of argument in that literally nobody knew it was her. And that's the argument. There was no right of violation because there is no association with it. Whereas, again, talk about that Michael Jordan case, talk about it, it's very clear who you're referencing. You know, that sort of thing. Sort of the immediate one that sort of jumps to mind is if somebody was to put, you know, a green and black Indy car up and, you know, refer to, you know, female Indy car drivers, it's pretty clear we know who you're talking about.
Yeah. How many are there?
Yeah, exactly.
Yeah.
So why do we have these rights of publicity in the first place? We're just trying to prevent people who are, you know, have like a famous brand from being taken advantage of? Or?
Yep. So it's to prevent companies from taking advantage of people's rights. You know, when you think about celebrities, think about the value of Michael Jordan's contract with Nike. I don't know that they've ever disclosed the number, but he makes an absurd amount of money selling his image, his persona, his likeness. So if other companies can just walk right out there and use it without getting permission, that dilutes the value of his brand. It could also, you know, piss Nike off if Reebok were to go and take it, which actually is what kicked off one of the cases that I wanted to talk about, which is in the social media context. And it's one of the most famous social media litigation cases that's happened thus far. I think I had value to my job as a social media attorney. You know, I'd been pitching to people that social media law is important, and then the Katherine Heigl case came along, and suddenly all my clients really believed me. So,
because you've been doing the social media is a thing for a long time.
Before social media was really a common household word. Yeah.
Oh yeah, back before Facebook had cover photos, I was doing social media law.
Well, talk about the Katherine Heigl case.
Yeah, so for those who aren't familiar, Katherine Heigl one day was walking in New York, went to a Duane Reade store, bought a bunch of stuff, walked out of the store with 2 big bags full of Duane Reade products.
So for those of us who are we Midwesterners, what is Duane Reade? Yeah.
A Duane Reade is similar to a Walgreens or a CVS. So general, drugstore with groceries and makeup and hair tchotchkes. So a paparazzi photographer snapped a picture of her walking across the street with her bags leaving the store. I think the picture got sold to TMZ or one of the other gossip sites. They posted it on their Twitter account. And then Duane Reade saw it and got super excited and immediately tweeted it out themselves with a tweet that said, at Katherine Heigl. Of course, they tagged her because they wanted to get all of her followers as well. Even at Katherine Heigl can't resist a good Duane Reade run for some makeup and other goodies. You should check us out. Hashtag Katherine Heigl. Hashtag 15 other things.
Got issues beyond just rights of publicity. Like, you don't actually know why she was going.
Exactly.
For all you know.
Well, she's
it was
making
really
a run.
cold and she didn't want to walk all the way to Walgreens.
Or she's buying something from a friend at their request. Or,
Yep.
And the other thing with it is, I think it's important to point out, this was a paparazzi photo. I mean, this is something that these
So
random...
there's also a copyright issue because Duane Reade did not own that photo. And
No, TMZ did.
No, exactly. And it's a commercial use. It was fraught with peril to begin with. But, of course, Katherine Heigl sees this and...
Because they tagged her.
Yes, sees this, and then fairly shortly thereafter gets a call from the lawyers over at CVS, where she has an exclusive endorsement deal.
Whoops.
And they say, WTF. Uh-oh. So even if she had wanted to resolve it in a nice manner at that point, I don't think she had an option to resolve it in a nice manner. So she had her lawyers promptly send a take it down now request to Duane Reade. We don't really know the details, but for some reason, said take it down now request was ignored. And after the deadline of take it down now or else lapsed.
or else happened.
Yeah.
Or else happened.
The take it down now always has a buy clause.
And promptly after the expiration of their grace period, Duane Reade got sued by Katherine Heigl for over $7 million.
Yikes.
One tweet.
I'm guessing that number bears some relationship to the value of her exclusive with CVS.
I suspect that it does. I think it was very easy for her to make...
To quantify her loss?
To quantify her loss for the non-consensual use of her image. So the case ended up settling out of court for an undisclosed amount.
This is more normal settlements.
This is a more normal settlement.
The undisclosed amount is more than 0 and slightly less than 7 million, most likely.
And I believe there was a charitable contribution to one of her supported charities as part of it, so that the little people got some good done in the world, too.
I'm glad they're thinking of us.
Yeah. Katherine Heigl has a heart, Ben.
All right. Well, I never would have said otherwise.
Yeah. So we don't know exactly how much it ended up costing Duane Reade, but I mean, they were on the cover of every paper in the country getting sued by Katherine Heigl, and I'm sure their lawyer bill was not small.
No,
because
probably less than $7 million and greater than 0.
Well, and most social media accounts are not run by lawyers and things, especially on Twitter, which is all real time. You're not going to screen. If you stopped and asked your lawyer about every tweet in advance, you may as well not be on Twitter.
Truth.
Yeah. I think the interesting thing about it, and it's, I've heard Charla give presentations before and talk about this case, and I know when you do these, this is the podcast, we don't have a video component, but when you see, the tweet that pops up, because you have copies of the actual tweet and the things like that, it's one of those where when you look at this, it's one of these things where anybody who's on Twitter, you can see this happening so easily. And to know that, as you said, one tweet resulted essentially in a $7 million lawsuit. And you got to kind of look at it from the other side and going like, wait a minute, what did we do?
Exactly.
We just retweeted something.
Yeah. And I mean, if you think about someone who's not familiar with the concept of publicity rights, they're going to think, what did I do wrong? I didn't lie. There she is.
Yeah, I'm
with
just describing
the bags.
things that actually happened.
Of course. She literally bought all this stuff in our store and we tweeted about it. How could this possibly be wrong?
Yeah, and I think that's the most interesting thing about it. I think that's a lot of it, sort of for us to get into here is, if you're on Twitter, you're on sort of any of these social media sites, a lot of times fans, and things is, you're going to repost, hey, look, the new trailer just came out, we're going to repost, here's this trailer. And a lot of times those are not necessarily the official YouTube video for the trailer because somebody may have gotten it a hold of time, or this is the Japanese one that's not supposed to be on YouTube.
But how many fake trailers have you and I been taken in by?
A couple of which are really actually pretty good.
I called you over for that one. I'm like, Kirk, this looks amazing. Episode 8. And we're like, wait a minute. This
isn't real.
This is a video game.
And of course, with those things, you have all the traditional IP rights issues, the trademark infringement, the copyright infringement. But I think where the line gets crossed with publicity rights is when it's a commercial use. So if I were to just tweet out on my personal Twitter account a picture of Katherine Heigl leaving Duane Reade and just say, OMG, look whose foot I stepped on at Duane Reade.
Yeah.
Entirely different.
Or what about
than
TMZ?
when a company.
I mean, they're making a commercial use, but it's a different kind of use.
Different kind of use. So
their business is reporting on, I'm going to editorialize, mindless celebrity gossip, right?
True. And they hide a lot behind that editorial news reporting defense, the same ways they probably do for copyright issues.
Yeah. I mean, news reporting is a for-profit enterprise for the most part, too. It's still
like the New York Times does not make money. Yeah.
But I think courts have distinguished between, yes, the New York Times, they don't give their paper away for free.
Yep.
But there's a difference between Katherine Heigl's picture in a story in the New York Times and the New York Times running an ad for their subscription special with a picture of Katherine Heigl on a bus bench reading the New York Times.
Yep.
Yeah.
It's like, come on. You clearly crossed the line at that point.
Yeah, and I think that's the thing with it is you sort of look at the TMZ use of this and you say, hey, there's a newsworthiness exception, and that is a sort of accepted thing in publicity is that somebody who's newsworthy, and obviously a celebrity is newsworthy regardless of whether they're,
especially for TMZ, which is their sole purpose for being.
And I think you get into a lot of that, there's a very clear line there that you can't say for everything, but where does it get away from this is news? And that's the argument where it wasn't the fact that they reposted a picture, it's the text they put underneath it that was clearly saying this is an ad for us, even though at the same time they weren't misstating what the picture showed.
Yeah, like would it have come out differently if Duane Reade had just retweeted the picture and said nothing?
Yeah. So I deal with these issues with clients all the time, and it kind of depends on where your risk spectrum is. I think the FTC's position is that they are going to look at anything that a commercial enterprise does on its social channels as default commercial activity. Because why else would you bother? Why would you hire these 22-year-old kids at $60,000 a year to run your Facebook account unless your entire purpose in having a Facebook and a Twitter account is to sell your product? You're not just out there to be a nice guy and a citizen of the
adding
social
valuable
universe.
Twitter content, 280 characters at a time.
Hey, it's all archived in the Library of Congress now.
So for most advertisers, it is an uphill battle to demonstrate that anything that you do on your social media page is simply news commentary. Now, I have had clients that are willing to take a risk a little bit, and you get kind of that middle of the road. So, for example, when the court decisions came down legalizing same-sex marriage, there were lots of brands that engaged and showed pictures of couples walking out of the courthouse together, celebrity couples walking out of courthouses together, all in the spirit of, hey, we support gay rights. I think much more of a gray area, and you've probably got a much better argument if the FTC comes knocking that, hey, this wasn't about selling our product. Now, if I'm the FTC, I'm going to say, well, why would you bother?
Yeah.
You want to look like a nice guy because, finish my sentence, you want to sell more product. But it's not as direct.
Yep.
So, I think with social media, the FTC, they find folks and they make examples of them. There are certain celebrities that you probably don't want to poke the bear on. So I would recommend not taking a risk with Katherine Heigl or Michael Jordan.
Or notoriously private celebrities like Harrison Ford.
Or anything owned by Disney.
Yes.
Let's just stay away from that purposely. I think we learned that
Stay
earlier.
away from Star Wars.
Let me give you one more what if. What if Dwayne Reed had themselves bought the photo and then they gave it to TMZ and let TMZ run with the story?
So if
Tricky.
tricky.
Ben wants to be a
we're
law school
actually
professor.
getting into another very interesting issue that I won't get too far down the rabbit hole, but that gets into something called native marketing, where there is content on social and on the internet that to the end user would appear to be very organic, news reporting, unbiased content. But little do you know, in the back end, a brand has specifically paid for it, provided the content, approved the content in advance. And the FTC has recently come out with some additional guidance on what disclosures are required when that activity is going on.
Well, we saw like a version of that with the last election and all of the bots and all that kind of stuff promoting certain content. This seems to be an issue that's going to get worse before it gets better.
They're definitely, I think one of the big issues you bump into with this as well is the idea of, like likes, people liking pages. And I mean, obviously pages can be liked by bots. You can buy likes effectively. I think that, that's not, I'm not letting the word, like raising the curtain on things people don't know here. But, that type of stuff with it is that you bump into and you say, well, the reason the page is so liked is because the person who did it bought likes. Now it's associated with something commercial. Wait a minute, is that organic? Is that not organic? What's going on here?
Well, I tried a couple years ago, just a sort of a thought experiment for myself, to make a Twitter account, never produce a single piece of original content, and see how many followers I could get. It took me less than a month of just retweeting and liking things to develop 1,000 followers. And that's me just when I got up in the morning and I'm brushing my teeth, retweeting and liking a couple things in a certain industry. Within a month, 1,000 followers. At that point, I was like, this is ludicrously ezy if I can do it with a couple minutes a day.
I've got you one better. You don't even have to be a real human being.
Yeah.
I was at an advertising law conference a few weeks ago, and one of the sessions that was most popularly attended was on bot Twitter users and their avatars. So there's one, and I cannot remember her name, but she's this avatar who's not a real person. She has a fake car and a fake dog and a fake life, and she has quite lucrative endorsement contracts with several companies to endorse their products. And one of the things that the FTC representative who was there was talking about was, where's the line for disclosure? First of all, do you have to disclose to the followers that this isn't a real woman? And then where does it cross the line with her endorsements? I think a bot can probably endorse a rapper and talk about how much she loves the music, but can a bot endorse shampoo and talk about how fantastic it makes her hair? It's impossible.
Along those lines,
Is there some deception there?
Presumably putting shampoo on the bot might cause a short circuit.
along those lines, though, if the bot's not a real person, what's to stop somebody else from reusing the bot? There's no right of publicity, right? Because it's not a real
There's
person.
not a right of publicity. I wonder if this is another place where technology is outpacing the law.
Well, I think in most places technology outpaces the law.
I think this is the latest one. We think about in-game. There are very, very popular in-game characters. What was that? There was a commercial. It was Ozzy Osbourne as a WoW character.
Yes.
Do you remember that commercial?
Yeah, it's a Snickers commercial, isn't it? You're not yourself
You're
when
not
you're
yourself.
hungry. Yeah, I think that was where that came from.
There have been a couple that have done that with I forget, there's a name for that style of animation where you're using like an in-game modeling system. Like South Park did a whole episode using it. Well, and that kind of gets back to the NCAA case we just talked about, where the players were all represented by in-game avatars that match their build, skin tone, facial features, jersey numbers, hometown, biographical information, but not their names.
Yeah, and even specific gear, like the way their face mask is built.
Yeah, and they're like, nope, that's you, and everybody would know it if they're paying attention. So it seems like it seems clear from that case that real people at least have some scope of publicity rights to online avatars that represent them. But then that raises other questions. Can a right of publicity prevent you from making a fictional use of a real person? So if I wanted to write a dystopian novel set 10 years from now and talk about things that have not yet taken place in our government, but say that they did, we have a very reality TV savvy president right now.
We do.
Might he, after he leaves office, take umbrage at such a story and decide to assert his rights of publicity?
Didn't we just say making science fiction?
Yeah, we just talked about that.
Isn't that what we just? I mean, what you just described in this is science fiction, taking something real world, moving it a little bit, making some assumptions and going forward
and speculating.
This is the core of science fiction. Are we looking at it and saying there's now potentially an argument that says science fiction violates right of publicity
if you use real people?
You use real people.
I think it's a tougher case to make when you're talking about literature.
And a politician, too.
And a politician, and a very public figure. Because, traditionally, literature, while yes, there again, why does anybody write a book? Presumably to contribute to the zeitgeist, but also to pay the electric bill with the sales.
We have a well-entrenched idea of artistic license. You can make a lot of general uses of real people in ways that are clearly fictional. Like Kurt Vonnegut would often include real people in his books. And
and obviously if you're going to do something like, hey, I want to write a crime thriller that's set now, I need the president to be the president. I can't make up some president. I can't I need real people to exist in it just to set the setting of what time period it is.
Mm-hmm. So I think in the literary context, there's a lot more wiggle room.
Yeah.
You do have to be careful, in that context of, what's going on right now, that you don't cross the line into slander and defamation and that kind of stuff.
So have you guys seen Futurama?
Yeah.
Love Futurama.
So I'm thinking of the Presidential Head Museum. Most of them are dead. So
Abraham Lincoln
sort of solves that problem. But they're not all dead.
No. And interestingly, depending on what state you are in, your publicity rights survive after you die.
Doesn't Elvis's estate still make
Elvis's estate, Marilyn Monroe's estate.
Yeah.
Still make millions of dollars a year off of their likeness.
Yeah.
Now, in some states, there is no postmortem publicity right. There was actually one of the big Supreme Court cases on publicity rights was an argument over Marilyn Monroe's domicile at the time she died.
That's the thing I would say, which state would govern it. Yeah.
Because one state recognized postmortem publicity rights and the other one didn't. So it's one of those things you got to be careful about. States also vary a lot in how you get permission to make commercial use of someone's image. In some states, it's enough if you've got your camera phone to walk up and say, hey, Ben, is it cool if I take a video of you to use in my commercial? And you say, yeah, sure, go for it. That's sufficient. Other states require there to either be a writing, you've got to sign a release with Ben Siders. Others recognize a less formal passive consent. So either you got to sign something or you've got to affirmatively say yes. Or in some states, just me putting up a sign at an event that says, hey, we're recording a commercial here today.
If you walk
in, you've probably seen these at cons. If you walk in, concerts, you are agreeing to...
There's a reason certain cons take place in certain states.
Yes, there's a reason I avoid certain cons as a professional attorney who would like to maintain her image.
And it's one of the things I think is interesting when you just commented about it, and you're thinking about this. Marilyn Monroe's the concern of where she's domiciled, where she dies. So one of the concerns is if you want to leave your likeness rights to your children, what state you die in matters.
Yeah.
You're sort of sitting here and you're like, wait a minute, I need to worry about what state I'm living in based upon the laws.
That's a morbid thought. Like, do you need to put in your living trust? Like, if I go unconscious, move my carcass somewhere else
before I die.
That won't work. It's the state of your residency at the time of your death.
Well, if you're unconscious, you can't establish an intent to remain anywhere. So.
Yeah, well,
but obviously you can have. For purposes of residency, do I decide that I'm going to be a resident of California? I'm going to buy a house in California, even though I have no intention of living there, so that my heirs can have rights to my likeness. If you think about it, that's just a weird trust in estates question.
I never thought when we started this episode we'd wind up talking about trust in estates and establishing where you're going to die.
But I think and maybe that's a good sort of thing to sort of some of this. And I think that's part of the reason, and I know like when, Charlotte and I, we talked about this earlier, one of the reasons I like this sort of topic as to what it is because this topic is becoming something that's just kind of permeating everything.
Well, it didn't used to be a big deal.
Yeah. And the sort of, the user-generated content world, the Twitter, the Facebooks, the YouTubes, and I mean, particularly YouTube, which is out there. Everybody's a star now. It used to be that stars were clearly defined.
That's the thing. And you look at, your streamers, your game streamers, your personalities. My kids are all into something called AWSD, which is some sort of Minecraft streamer. Don't Google it. Don't look it up. It is mindless nonsense. Sorry, ASWD, but I think that's what you're going for. My kids love it. They eat it up. But the people who do this are establishing a brand. They're establishing a personality. They're establishing these personas. They've got online Minecraft characters that have a certain look, and my kids want to look like them. So they go download the ASW, whatever, I can't remember the order now, ASWD skins so that their Minecraft characters look like these avatars of these guys doing YouTube streaming. And it's not a big leap to say there's merchandising and other sponsorship opportunities there for these guys. Can you establish some sort of right of publicity in a Minecraft character persona that is you? It's your voice, but it's a made-up personality. It's not really you. I mean, the Vanna White case is close. Vanna White obviously is more than a blonde woman who turns letters, but that's what you know her for.
Yeah. Exactly.
So if that's enough to infringe her right of publicity, can I not go out and make an ASWD thing to sell without infringing the right of publicity in this character? Yeah.
And I think this is an area where the world, we talk about, so the law catching up to the world, we have seen the world change dramatically. And I mean, it's one of my favorite statistics that I heard at one point in time with it when they talk about YouTube. And I remember hearing the quote that they said that currently every 7 minutes there is more content uploaded to YouTube than has existed on broadcast TV in history.
That's insane.
Wow.
And that's like, assuming that's a true statement as to what it is, that's an incredible amount of content. And how much of it's viewed, how many things how many stuff on YouTube has never been viewed. I remember there used to be I think it was a Pandora, like there was a system you could do for like one of the online streaming services. Yeah. I think it was Pandora, that literally was, you listened to songs that had never been played on Pandora. And as soon as you listened to it, it was removed from their playlist forever.
Wow.
Because it was only things that had never been listened to. And it's like, that's, these kind of things where it's like there's just so much content, it's so permeating, everybody's out there. What does that mean?
So do you think the right of publicity may be the last of the major forms of IP that does not yet have a comprehensive federal scheme? We have a Trade Secrets Act now, finally. Charla, what do you think? Is that coming someday? I'm wondering if that may arrive in I'm also thinking of some of the darker corners of the web, things like revenge porn and stuff like that, where copyright doesn't really work because the cameraman usually owns the. So there's I'm thinking there may be sort of the states are dealing with this piecemeal. Maybe that plus data privacy. These seem to be things that are heading towards a comprehensive federal regulatory scheme.
I think it's something we're probably going to have to get to if the world continues to evolve the way it is. I think my question is going to be, who's going to take it? How is the FTC going to assert jurisdiction? In theory, with most of the testimonials and endorsements, they can assert jurisdiction because they can say, hey, we have to protect consumers. We need to make sure it's clear to consumers that when someone uses somebody else's persona, that the consumer knows what the terms of the deal were. But I wonder how they're going to make an argument that they get jurisdiction over just private citizen, non-consumer transaction related use of rights. So maybe it's the patent trademark office?
That's what I was thinking. Do you do what the Lanham Act did and just say we're going to create a private cause of action and let the private market sort this out? Because philosophically, trademarks are a consumer protection technique as well. But the federal government never really enforces them at all. We leave it to the private market to decide which things are worth enforcing. So maybe something like that would work for right of publicity. I don't know. It's interesting.
Yeah. And I mean, to Kirk's point, as you think about it, 15 years ago, if a company wanted to make a commercial, they had to go out and they had to hire actors. Yeah. They had to have auditions. If they wanted to do a collage ad with user-generated content, that meant asking people to mail in physical photographs versus now, if you want 15 pictures of people visiting Disney World for Disney World to use in a collage ad, they can get all that in 3 seconds
Yeah, easily.
on a filtered Twitter search.
Yep.
All right. Well, we should probably wrap this up. Charla, thank you so much for coming. This was one of our most fascinating discussions.
We always
We
have fun
kind of
when
jumped
Charla
all
comes on.
around the legal world today.
Well, you kind of have to with this stuff. I mean, everything kind of bleeds into the next thing.
Yeah, and that's, I think, again, I think that's one of the things I like about this is an area that really is starting to bleed into everything and sort of everything we do. And I mean, as we said, we got into trusted estates law.
Yeah.
I mean, when are we going to get into stuff like that? Where do you want to die?
I think I now understand why the last episode was so popular. It's a deep topic. All right. Well, our next episode is still a bit up in the air. We're working to bring in some more guests, but we don't have anything concrete yet. So you'll just have to tune in and see. It'll be a surprise to us as well.
Exactly. Yep.
All right, there's the music. It's time to go. If you have questions, comments, topic ideas, criticisms, complaints, remarks, adulations, or rants,
Or want to hire us as a sponsor.
or you can send your thoughts to us on Twitter at LGGPod or email us at lggpodcast@gmail.com. You can also talk to us on our Facebook page, search for Lawyer's Guide to the Galaxy, and find us there. Subscribe to this podcast on one or more of the platforms, or all of the platforms. You can inflate our listenership. We are on iTunes, SoundCloud, Spotify, and the other places where you get your podcast content. If you like what you hear, give us a review. Reviews are how we attract more listeners by making it easier for others to find us. You can find me on Twitter at Benjamin Siders. Kirk is at KirkDMN. Charlotte, do you have a Twitter account? Or any other place
at
people
Charla
can...
Claypool.
There you go, at Charla Claypool. All right, that's all for today. We'll see you next time. Lorem, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded at Cool Fire Studios in St. Louis, Missouri.